course.
There may be
Right,
a
sir.
people thinking we have little experience. You may have more experience on that side, but
Sir.
the kind of investigation, the kind of prosecution is carried out,
Sir.
probably everything ensures acquittal only.
Sir.
Right? And see, we have reproduced the list of cases against him.
Course.
There may be
Right,
a
sir.
people thinking we have little experience. You may have more experience on that side, but
Sir.
the kind of investigation, the kind of prosecution is carried out,
Sir.
probably everything ensures. Yes, Mr. Pandey.
Sir, good morning, sir. And I've just joined, so I've just come to know of this case. And what I have come to learn is that this bail was granted in October last year, and at that point of time, this particular accused was already in custody in another trial, and that particular case is under very good investigation, and we are heading for in custody trial and would possibly end in a conviction. So that's why at that point of time, the officers didn't actually show that inclination.
Mr. Pandey, that you can't say may result in conviction and all that.
Sir,
right?
Of course.
There may be
Right,
a
sir.
people thinking we have little experience. You may have more experience on that side, but
Sir.
the kind of investigation, the kind of prosecution is carried out,
Sir.
probably everything ensures acquittal only.
Sir.
Right? And see, we have reproduced the list of cases against him.
Sir.
So this is how the state wants to maintain.
Sir.
This is how you will maintain the law and order.
Sir.
In the,
So we'll go on.
In the earlier case also, we had pointed out to the state council.
Sir.
Earlier, the concept used to be that all crimes are against the state. The state will prosecute and defend whatever is there.
Right.
That's why the law had to be amended. Now the private complainant victim has been given the rights because the state is not doing anything.
Right, sir.
We never wanted to interfere in this SLP.
Sir.
Because he was not the person aggrieved upon. But once we saw all the facts, we had to issue notice to you.
Sir. We'll take necessary action as per the direction.
Necessary action now you will take.
Sir.
Now it is before us, we will take action maybe against some other persons also who may be involved in all this.
Sir.
Who may be conniving also.
Sir.
You may have joined now. There were officers who were dealing with this case before that.
Sir.
Anybody is responsible?
Sir, if I'll just examine that, and if required, we'll do the needful, sir.
You have to tell us who was the person responsible and what action you are taking against him.
Sure, sir.
Well, may I just now, after that, may I make one suggestion? There were two reasons what was.
Let everything come on affidavit.
Yes, it will come on affidavit.
We have to take this to the logical end.
Yes, there's one more aspect. Because your lordship is absolutely right. It should have been the state which should have come because the petitioner here.
In 90%
Yes,
cases,
yes,
victim or the
yeah, right item. There is no absolutely your lordships are right. In fact, in this case, it highlights why the petitioner is also a gangster with 17 cases against. Yes.
When such type of facts are here, that
Yes,
he is having 17 cases against him, it's not the duty of the state to file an SLP.
Correct. The reason they say is
You
because
kept
in
quiet
another
for
case he was already in custody, and in this matter the trial would have ended in 3 months. So they didn't anticipate that he'll actually be released.
What are you saying?
Well,
What are you saying?
that's the reason. Well, it may have been wrong, but that's the
You
reason.
will accept this reason.
You
will accept it before putting it to the court.
Plus, it is.
He also said maybe conviction.
Well, that
all
of course.
wishful thinking.
Well, that of course. I bow down to that. But today he's not in a risk of getting out. That's the thing.
He have passed the order.
Reason and, tomorrow, if the bail is granted in that case, then
Well, bail has been rejected.
then you will challenge this order.
No, well, your lordship is right. It's not the ideal way. I'm just putting to the court what was their reason. It is certainly not ideal. Malad, as a counsel, I'm had item with the court. Malad, my lord may take it.
You were defending on the last day.
No, Malad, I was personally not appearing, but now I think I am appearing for the first time.
We do not know. We are not concerned with that.
Of course,
So was the counsel. He was defending all this.
Well, that shouldn't
With
have
the
happened.
change of counsel, the concept.
No, that shouldn't have happened. That shouldn't have happened. I agree. There's no. We should have filed. We have not filed. This is a classic case. Why we should have filed?
Not classic cases. There are many such cases coming.
Correct. I appreciate that.
Recently, we had dealt with another case also. Anticipatory bail in state never challenged in 302.
And then the private party has to come. Absolutely.
So this is what is happening. That also must be in his knowledge. The bureaucrat.
So anyway, the reason for in this matter is this. It may not be a correct decision as your lordship put it, but that's the reason.
No, you just supply the reasons why the other person or responsible person has not filed. They are challenged
That
that
will
file in that.
You are for the
I am the person who's inside. Gives me 1 minute to explain to your lordship what has happened. But it takes my counter.
you file.
Well,
You file.
That's
That's a counter affidavit. Your lordship will see.
Yes, it takes
Fine,
600
fine.
pages.
Consider that.
But I already filed. But it sees for 1 minute.
we are not deciding this SLP.
No, I understand.
The
These pages,
merits, we are not going into the merits. Here the
But
matter
one
is whether the
explanation
state has
needs to
not filed
come
this.
from the state. Your lordship will see one explanation needs to come from the state itself.
That's
When it sees page 3, everything will be clear. Of my of the summary mallet, your lordship would see preliminary submissions. Your lordship would kindly see page 3 once, paragraph number B.
Give me liberty to file a
But I
rejoinder.
understand
both
Yesterday.
petitioners. Just 1 second, sir. Both petitioner and respondent have 17, 18 cases. So this is the ideal case where the state should have come. I straight away.
So your idea was to support one?
Of course not. He was.
This is the
Well,
result of your
no, your lordship. Plus,
or to support both.
can't be. So, this is the ideal case.
Reason you know
Yes.
what is coming in future. Do you need these kind of people?
People. That's right.
No, they should be inside.
No?
Absolutely. They should be inside. They should be inside. Absolutely.
Then who will
You know
manage
these
all
kind of people outside?
They shouldn't be outside. Absolutely.
They are.
They shouldn't be. Right. I'm mad item with the court on that. Absolutely.
But possibly the Honorable Supreme Court, this Honorable Court has already dealt with this matter, my lord. That is exactly what I'm trying to show your lordship before your lordship adjourns it to another day.
Yes.
Permit me to show it to your lordship.
Are we passing any order today against you?
So long as it's not passed. So
Then what
long as it's not.
we are simply seeking explanation from the
Explain
Also consider
who is the person responsible.
because I was released on bail, my lord, Supreme Court did not interfere in my matter.
That's right.
The matter came up before
We
Supreme
know
Court.
it.
The Supreme Court says that
Everything we had seen, we had not issued notice in his SLP. It remained urgent. But when these all glaring facts came, we just wanted response from the state.
the
Right.
petitioner themselves are accused of 111.
Fine, fine. They should also be taken care of. We are not
Yes,
in him.
yes, very.
Very good.
In terms of the order passed by this court on 28/11/55. Also, DGP, State of West Bengal is joint police. He submitted that he has recently taken charge of the post. The respondent number 2 accused was in custody in another case where the trial is going on, which was likely to be concluded within 3 months.
Well, that's in a few months. My lord may say a few months.
Few months.
Exactly. Yes.
Be that as the paragraph, be that as it may. Mr. Pandey, DGP, submitted that he has taken charge of the post recently. Let him inquire into the facts of the case and apprise the court by an affidavit as to why the state, which is responsible for maintaining law and order, had not taken appropriate steps in the case in hand, where the respondent number 2, who was released on bail, had checkered criminal history. Yet the affidavit will file 2 weeks to file the affidavit.
But that's why also give me liberty to file a rejoinder to the counter of harm.
We have not issued any notice that way.
Well, there's a 600-page counter that has come in 2 days back. Allow me, Malaz, give me liberty to file a rejoinder to that.
You may be lucky we don't have.
Malaz, there may be certain facts. They got it.
Joke say about.